Good afternoon, everyone. Welcome to the pension breakout session. It's great to see everyone in person today. So just a few of housekeeping item. So today session is taped, and we also have French translation. So whoever needs French translation, just raise your hand. We have headsets available in the room. And for those joining us online, I was told that you can click on some button. You can click on your initials, I was told, and then you can do your language translation there. So we are truly a hybrid kind of platform. So to give true spirit to it, we actually launching and using a platform called Chime to take questions. So we want to give the equal experience to both people in the room as well as people online as well too. So please do submit your question through Chime. We have a question period at the end of the sessions, and if you have, for some reasons, those in the room trouble answering the questions, please raise your hand. Somebody will be there to help you. So before I actually launch into the session, I want to do a little bit of commercial. You heard about the success of Pension Awareness Day. I want to take this opportunity to thank the entire sector for providing us with that support. The collaboration there is exemplary. And in fact, we actually have a lot of questions now about how to get involved even more next year. It's our hope that every day from this day on will be Pension Awareness Day. That's my hope. But officially, is the third Thursday of every February of every year. We want to make it a more grassroots event that everyone will be able to participate and talk about it. And I take complete comfort in that we will get there. And we actually even have other jurisdictions call on me and say, how do we do it? How do we get on board? So it's a great success, and kudos to our public affairs team who have made me look really, really good. So thank you for that. So nice segue to our session today. It's all about PBR, Pension Benefits Regulation. No, it's about principle-based regulations. So FSRA is a principle-based, risk-based, outcome-focused regulator. I'm sure you've heard a lot about that. I've been hearing about that since day one of FSRA launch. But what exactly is it? What does it really mean? Joanne's our board chair this morning talked about there are some sentiment around concerns or maybe misunderstanding about exactly how this will be implemented through the sectors. I've been with FSRA for coming up 6 years, believe it or not. The two most commonly heard comments are, at one end, it is, well, there's so much ambiguity. How can I comply? You have no checklist. How can I comply? To the other end is, well, you guys are principle-based. Can we kind of ignore this? So those are the two kind of goalposts that I've kind of experienced during my last few years as a regulator. So our session today is exactly about demystifying what PBR means for pensions. It's more than a few catchy phrases. I'm hoping that through our panel here to tell you a little bit how we apply PBR in our day-to-day work, will demystify for you what PBR actually means. So at its core, PBR is about collaboration, about shared understanding and commitment. It's more than just about having rules that is principle-based, but it's also not about ignoring law. So without further ado, I want to introduce my panel, who are all my colleagues from FSRA Pensions team. To my right, I'm an actor, but I can't tell that from right, is Risha Hossain. She is the Director of Legal Services and Deputy General Counsel. To the right of Risha is James Hoffner, Chief Prudential Supervision Officer for the large public sector pension plans. And the far right is Paul Martiniello, Director of Prudential Supervision, mostly for single employer pension plans and multi-employer pension plans. To my left is Claire Woodcock. She is the Director of Pension Plan Operations. And the far left is Trevor Cartledge, Deputy Chief Actuary. And my name is Andrew Fung, Acting EVP of FSRA, and I will moderate the sessions today. So, without further ado, let me just start off with perhaps Risha. We have a draft principle-based regulation approach guidance that we consulted on in 2022. Can you give us a little bit of background about that guidance and share at a very high level a little bit about the comments that we have received so far?
So I think I'm going to start with that. Oh, by the way, so nice to see so many familiar faces. Thanks so much for joining us today, and nice to see new faces. It's really great to be able to be here. Thank you, Andrew, for the invitation to talk about principles-based regulation. So what I'm going to start off with is just a description of why principles-based regulation. You've been hearing a lot about it today. So as many of you know, before FSRA was created, there was an expert panel that was established to look at the mandates of both FSCO and DICO. And what they concluded, as many of you are familiar with, hopefully, is that due to the quickly changing nature of financial services regulation, which we heard a lot about this morning, there was a need for an innovative, flexible, adaptive, and responsive regulator. So an essential tool, this was their recommendation, in supporting this approach is a principles-based approach to regulation. By this, it means that FSRA will look to high-level principles to guide our regulatory action. So let me just start with a quick definition, and I know I'm going to sound like a total lawyer by starting with a definition, so let's talk about what is principles-based regulation. The classic example that's used to demonstrate between a principles-based and a prescriptive approach to regulation is the highway traffic rule example. So in a prescriptive framework, you go onto the highway and there's a clearly posted speed limit. You may not travel faster than 100 kilometers an hour, right? We're all relatively familiar with all that. In a principles-based environment, the speed limit would be stated in a different way, looking at the outcome that we are all trying to achieve, which is safe travel on a highway. So the rule or the requirement on the highway would be do not travel more than at a speed that is faster than is reasonable and prudent in the circumstances. So, as many of us, because we are in Toronto, are familiar, when you're driving on the highway and there are conditions of black ice, you would be traveling perhaps 40 or 50 kilometers an hour, depending on the traffic. And a clear day, your car's well-tuned, gas in the tank, very little traffic, you might, and I'm not encouraging you to go slightly above the speed limit. Perhaps you would say that 120 kilometers an hour would be very reasonable in the circumstances. So that's so what we're trying to focus on, as Andrew, I think Mark mentioned this morning, is focusing on the outcomes that we're trying to achieve. So, you may ask, what are those outcomes? What we look to as a regulator are our statutory objects. You've been hearing a lot about that. But for the pension sector, it's the protection of the rights and interests, rights and benefits, you'll forgive me, I should know this off the top of my head, of plan beneficiaries, as well as the good administration of pension plans. So these are the two key things, as well as the other objects for financial services that'll guide us in the way that we regulate the pension sector. So I would also say, as legal director, the PBA, as many of you know, and some of you have complained about, is a very prescriptive statute. So what we're trying to do, and what we are doing in many cases, whether you see it clearly in our guidance or behind the scenes, or even when you're talking with a pension officer, or Claire, or Paul, or James, is looking to an interpretation that supports the outcomes that we are trying to achieve, and it is a broad, purposive approach to regulation, to statutory interpretation. Now, this is not a new concept. Many of you who went to law school with me just a couple of years ago would say that a broad, purposive approach to statutory interpretation is not new. What is new is the case law, administrative law case law, that talks a bit about what that framework for interpretation should be. So I would encourage lawyers in the room to look at the Vavilov case law, and there is a clear link to a rational connection to the statutory objects. It is not anything goes, but we will be guided by our statutory objects. So that's what we're doing and the outcomes that we're hoping to achieve is what I'd like to talk about a little bit next. So you've heard today also that we're an outcomes-focused regulator. Where do we get those outcomes? We get those outcomes by identifying with our expertise as the regulator, what are the problems that we see as we attempt to solve them. There's an opportunity in many circumstances for you to provide your feedback about what you think the desired outcomes should be for an expert regulator. That would be in guidance, the consultation process or the consultation process with rules, or even speaking to the pension officer that is reviewing your plan amendment or dealing with you on a transaction or with respect to potentially a member complaint. So I think I'm probably running out of time, but I'll quickly say the other important thing to think about is how we are regulating you. And that's what Andrew described as our principles, the guidance on principles for the pension sector. That's going to be rolled out into a new guidance that's likely going to be issued in the spring that talks about how we will regulate the sectors and what you can expect. You can expect us to be, and these are, I'm not going to go through all of the guidance principles, but the key concepts I think for this audience would be that we're going to be risk-based, we're going to be transparent, we're going to be collaborative as we try to identify the best approach to solving the difficult regulatory problems that we're faced with as a regulator. And that's pretty much it for me, Andrew.
Great. Thank you, Risha. So this is a very helpful overview to frame our discussions. So PBR certainly doesn't mean that we disregard the law, but I think it requires the pension plans we regulate in administrating its requirements. We kind of take it up one notch higher by also considering the purpose and our objects, quite a deviation from, I think, previous administration. So ambiguous it might be, think flexibility. Those two initials, A and F, is very dear to me. Andrew, Fang, ambiguous, flexibility. So things flexibility when you think about ambiguous. I think how plan administrators can develop their own ways to achieve the desired outcomes, are best suited to each unique circumstances, but also take into consideration the purpose of our act. But there will be situations where we will impose kind of bright line requirements to ensure, for example, plan beneficiaries are adequately protected. Did I get that right, Risha?
Absolutely. Sorry. Yes, Andrew, I would agree with that. There is this concept that's not unreasonable that when we talk about principles-based regulation, that there would be an absence of rules. So at a high level, that's correct. But I would also highlight that we're both a principles-based and outcomes-focused regulator. And the rules are inherent to support the outcome that we're hoping to achieve and also underlie the principles that we are setting to establish. So there's another highway example, if you would permit me for another moment. It's the Autobahn. My colleague Joan Small and I have been working a lot on training. We've been training internally with FSRA. And it's interesting that there is this, you can drive as fast as you want on the German Autobahn. We're all relatively familiar with that concept, right? What we're not necessarily as familiar with is there are a list of rules or requirements that underlie that broadly based, you can drive as fast as you want. Things like you cannot run out of gas on the Autobahn. Your car has to be well tuned. You have to drive on the road conditions. I can't remember all of them. I have to apologize. But there's a list of at least 5 of them, and they are well known to all the people, particularly the Germans, who are driving on the Autobahn all the time. So I'd ask you to consider that a principles-based framework is not inconsistent in some cases with having bright line rules, because one, sometimes rules are required to support the achievement of the principle. And also in some cases, we may decide that a bright line rule is what is required to support our statutory objects, protection of plan beneficiaries and good administration of pension plans. So don't be surprised.
Thank you, Risha. I now want to turn to some real examples as to how we apply PBR in our work. So Paul, can you share with us how you have been applying PBR in your day-to-day work, specifically with the single employer pension plans and the multi-employer pension plans?
Yeah, thanks, Andrew, and good afternoon, everyone. So I'm going to get my acronyms out of the way right away. Single employer pension plans, or SEPPs, and multi-employer pension plans, or MEPPs. I've had the pleasure of joining FSRA in late 2019, and just as we were developing our approach to prudential supervision of MEPPs and SEPPs, and so we were really able to do that and build it on a PBR foundation, which we have done, and of course to support our FSRA objects. And you know, I'm going to say right off the top, the feedback we've received in our travels over the last several years has been positive. I think the approach has really resonated. This collaborative, transparent, proactive approach has really resonated with the sector. And if you think about the FSRA objects themselves, as a pension administrator, they wouldn't be too dissimilar, right, in terms of ensuring good pension administration and ultimately protecting the benefit for the beneficiaries. So anyway, I'd love to hear others' thoughts. I have heard from some. I recognize some faces in the rooms, and if not in today's forum, and please don't hesitate to reach out one-on-one to us at any time. To step back a little bit about operationalizing this starting in 2019, you know, you can think about people, process, and technology, right? So one of the keys to being collaborative and proactive is to have a relationship management discipline in place, and so we had to build that out. We also, as part of Andrew's team, built up much broader and deeper skill set right across all aspects of managing and administering a pension plan. We added some tools in terms of allowing us to be more dynamic and being on top of what's happening in the economy and capital markets, and looking at credit ratings, sponsor risk, things of that sort. And we did this as we concurrently had established the Technical Advisory Committee. Here I go with another one. You heard that, Joanne talking about that this morning. We have a DB SEP TAC as well as a MEP TAC. And really critical to helping guide us for the MEPs, we established a roadmap of the work we wanted to do over the next several years, 5 years. And with the DB7 in particular, there was a guidance put into place on our supervisory approach for single employer pension plans that are actively monitored. And this guidance is an excellent example of a PBR approach. It's a nice, succinct 7-page guidance. If you haven't read it, I highly recommend it. And it's really important for us and our team as a communication tool as well, because we basically, in a proactive way, are taking the information that we have available to us through filings, through publicly available sources, some of those tools I just mentioned, and really establishing a risk profile. And if there are single employer pension plans that we're concerned about, then we want to proactively reach out to the fiduciaries to have a detailed conversation around some of these concerns. And so we assess things like sponsor risk, funding risk, investment management risk, compliance risk, and these conversations that we have, and usually they're attended by senior people, fiduciaries of the plan, are really insightful and critical for us to understand better if our assessment of that risk level is accurate, and to be able to reassess it and move forward there. So we take that information back. Essentially, it forms a feedback loop, if you want to look at it that way, that we go back to an internal steering committee that we have that then helps us reset our engagement strategy. And we're very transparent with the sector as we're going through these discussions as to what kinds of things what our views are, et cetera. So that's, again, part of our commitment to maintain that transparency. It's been an interesting journey. We've had plans that we've noticed some behavior around fiduciaries taking the pension plan members much more into consideration when they're making decisions around capital cost allocations, for example. So in other words, treating the pensioners as a silent creditor, if you will. We've seen certain plans make additional contributions above and beyond the minimum. to their pension plans in advance, or maybe as part of making other capital allocations. We've seen de-risking activity take place in the form of immunizing a portfolio a little bit better, or even annuitizing. And I'll make another comment. As you're probably familiar, the single employer pension plans in Ontario have the PBGF, or the Pension Benefit Guarantee Fund. And so the CEO of FSRA has a fiduciary responsibility to the PBGF. So this work helps the CEO discharge that responsibility as well. And on the MEPP side, I mentioned we had a roadmap put into place. The first thing we did was a thematic review in 2019-2020, where we looked at a third of the sector. That was really critical for us to get a better understanding of the kinds of challenges, issues, and also leading practices that exist in the multi-employer pension space. We then collaboratively, again, with the TAC, produced a leading practice guidance, which was published in 2021. And those 8 leading practices fall into 3 buckets: governance, risk management, and communications. And in that leading practice guidance, we committed to then going forward and benchmarking, so having each MEP in Ontario benchmark themselves against those leading practices. And that's been a really fascinating exercise. That's actually coming to a conclusion now. We've also seen some tangible improvements, if you will, in our journey in the last few years in terms of fiduciaries of multi-employer pension plans enhancing their overall governance and risk and communication approach, as well as policies. Like in some cases, their policies existed, they were enhanced. In other cases, they didn't exist at all, and they've been either put into place or in the process of being put into place. And the last comment I'll make on the MEPs has to do with the fact that many of you are probably aware there's a target benefit framework that the Ministry of Finance has a proposal out there for a permanent framework. And the work we've done has a lot of synergy and integration with that work moving forward. So those are 2 examples of the work I do. I will mention quickly, Andrew, the examination work, because our team also, from a prudential supervision perspective, handle examinations of plan administrators, specifically MEPs and SEPPs. And we've done a lot of work in revamping that process such that it becomes a principles-based. We've moved away from more of the prescriptive checklist approach. So we've been piloting that this past year. It's been a great exercise. We're now in the process of implementing that moving forward, and there'll be more to come in a webinar that we're going to be putting out there sometime in April or May of this year.
Well, thank you, Paul. I think, Paul, you actually have highlighted for us through your work in the MEPP how FSRA may leverage a thematic review, might leverage a set of best practices out there to guide us. These best practices are by no means compliance checklists that you have to do, but basically will give us as a regulator and the regulated entities perhaps a baseline, a reference point for us to, and you as the regulated entities, to evaluate how your own approach, which may differ from the best practice, will satisfy yourself in terms of achieving your own outcome. I think the MEPP work is also, through your best practice paper, is a great example of how collaboration with the sector lead us to good results. And the TBP, for example, the funding framework for the target benefit plan, industry wants no prescribed PFATs, provisions for adverse deviation. I'm an actuary by training, by the way. Just forget some of the acronyms. This is what the industry is asking for, and we look forward to more collaboration, because as we implement the regulatory guidance in respect to the new target benefit plan approach, there will be more conversation. There will be a lot of open dialogue that is required for the upcoming months. So, and it will involve a lot more judgment than prescribed checklists and prescribed rules. So thank you for that, Paul. So let me turn to James. So James is instrumental in leading the work of our large public sector pension plans. You heard Mark talk about why he's spending so much time on the JSPP work. James, can you tell us how risk management is factoring into your work on the large plans, and tell us a little bit more about why, in addition to what Mark said this morning, we're developing a supervisory framework and where we are today.
Okay, thanks, Andrew. So we are taking a bit of a different approach to the large plans than what Paul was describing, although there's commonalities with Paul's approach. As noted, these plans manage complex investments. They are successful, and I think it's fair to say they are well regarded, and they've been successful plans for our sector. But they also carry a fair amount of risk. It's worth recalling the IMF report from a few years ago, which drew attention to the rise in risk-taking at these plans, pointing to the increased leverage and increased illiquid assets. And from our perspective, the large plans are a major part of the pension sector. They account for 65% of pension assets and close to 40% of pension members. So it stands to reason, I think, that we need to have a supervisory strategy for these plans. If we focused only on a compliance approach to the prescriptive components of the PBA, that wouldn't get us very far in terms of our statutory objects of protecting benefits, promoting good administration, contributing to public confidence, etc. Instead, we focus on the standard of care. We seek to understand and assess how plans are complying with their standard of care. In the past 2-3 years, we've been getting to know the plans. We've been learning their strategies. We've been learning about their risk exposures, their management techniques. We've also been building relationships and having good discussions with the plans about what supervision can mean for their sector. We're at a point in time now where it's appropriate for us to put our activities, to put pen to paper vis-a-vis our activities. So you'll have noticed in the proposed statement of priorities that one of the priorities for the upcoming fiscal year is to issue a guidance. So assuming those priorities are ultimately approved, that's something for you to look forward to. In the meantime, I want to share 3 ideas that illustrate how we think about the supervision of the large plans. First, we're focused on governance and risk management. Pension plans aren't banks. They're not commercial enterprises that are going to go out of business. So we're not going to take a Basel-like solvency approach to supervising these entities. Our lane is about their governance and risk management practices. And there are established approaches to assessing these practices that other prudential regulators have developed that we can learn from, borrow, and adapt as appropriate for the pension context. Second idea I want to raise is the principle of awareness. We are aware that plan administrators bear the responsibility of plan administration. Our role is not to set investment strategy, it's not to set risk appetite. Our role is to assess whether the governance and risk management activities are appropriate and effective and meet the standard of care for those investments and risk appetites. I'd like to take a moment to talk about the AIMCO loss during the pandemic. So what happened here is that AIMCO had a volatility trading strategy. In 2018, it expanded the strategy to become both riskier and larger. But the problem was at the time, the risk function had a legacy system that could not properly model the tail risk with this investment. And this was known at the time. When the risk function was able to update its systems, it was too late. The pandemic happened, markets moved, and AIMCO lost over $2 billion before it could exit that strategy. So this is an example of governance and risk management failure that could well have been avoided. The third idea I want to leave with you is one of expertise. Each of these plans employ smart, hardworking people. Our job is to access and leverage that expertise. So take the AIMCO example. My team has some smart people on it, but if we were reviewing that investment strategy, I don't know if it would have been obvious to us that the model would have been deficient. But I'm not sure that that is critical to our success. When we ask pension plans to demonstrate how they are meeting their standard of care and their risk management practices, we can ask them, do you have any gaps? Do you have any concerns? When's the last time you have had an external review of your models? Are there things that you're changing or want to change? Why do you want to change them? Among various metrics or techniques, what do you rely on most? And it's by asking questions like that and using our independence as a regulator and our view of the overall sector that we can have an informed view and engage with the plans. And that's ultimately how we see playing a role in the ecosystem that's constructive, and that's how we can also demonstrate to our board that we're carrying out our statutory objects. So Andrew, I'll stop there and turn it back.
Thank you, James. Thank you. Hello? Thank you, James. So I think you actually have demonstrated that how we actually have interpreted the pension plan's fiduciary duty more contextually to determine the requirements of large plans to have robust risk management practices. I think FSRA desire to ensure that risk management practices in place fall squarely within our statutory objective. I just want to repeat that we fully appreciate that these are very sophisticated plans. They actually have in place very robust strategy and whatnot. I just want to reiterate, what we're doing here is not to second guess any of the investment decisions. We don't have that expertise. We actually have been engaging the large plans over the last few years to actually have regular phone calls with them to make sure that we are on top of what they're doing. So it's really nothing more than that. We want to start understanding their practices. Joanne, our board chair, mentioned this morning we want to collect data. Our going-in position is that these plans know what they are doing. We're there to verify that, in discharging our duty to verify what they have done is in fact right, and it's really try to understand a little bit more how they structure themselves, how they structure a team, but it's not to second guess their investment decisions whatsoever. So let me now turn a little bit more to how our day-to-day work on the operations side. So can I turn to Claire and Trevor to perhaps let us know how you've been applying PBR in your day-to-day work, whether it's intake from an inquiry or filings from plan administrators, and how, Trevor, you've been taking that principles in assessing, for example, the actuarial robustness of the plans.
Thanks, Andrew. I think there's three main areas in which the operations team is trying to incorporate a PBR approach into our everyday work. Firstly, by taking a risk-based approach when performing our regular compliance reviews and related checklists, so that not every tick box is given equal weighting. Consistent with our guiding object to promote good plan administration, I think it's always important to point out deficiencies to plan administrators so that future applications have a stronger likelihood of being fully compliant. However, depending on the nature of the deficiency, FSRA may choose to overlook a requirement if we view that there's little to no harm. For example, the notice requirements on asset transfers and conversions are quite prescriptive. Some of the information, if missing, may not impact transparency or overall consent levels if required. However, some information may be critical to a member's decision-making process, for example, any information regarding benefits or entitlements or contributions. And if that's missing, we may require a supplemental notice to be mailed out. The second area I'd like to highlight is how FSRA is trying to become more proactive than reactive. In the past, we've been very focused on information, filings, and submissions been made to us, and less so on information that should have been filed with us, but hasn't. Information that isn't filed with us could be indicative of a problem in plan administration, plan governance, a corporate restructuring, or at the worst end, an employer insolvency. In the summer of 2022, FSRA recommenced its processes for going after outstanding filings, and we reached out to over 250 plan administrators to find out why their filings were late. And the overwhelming reason why information was being delayed in their filing was because people were unaware of key filing deadlines or were not set up on the pension services portal correctly. As a result of that observation, we developed 2 at-a-glance documents that set out the requirements for DC plan administrators and mailed them out to all plans, as well as mailing them out to large insurance companies. The second thing we did was created a short video to outline to plan administrators how they can update their information on the Pension Services portal. The third area I'd like to highlight is how we're trying to be more collaborative. We recognize that plan administration isn't easy, and we're open to listening and providing feedback where you run into trouble, but not necessarily providing you with the exact answer. Administrative errors happen all the time as we all make mistakes. We're open to having a dialogue of what might be reasonable and appropriate in the situation to fix it, and we're open to also making sure that these errors don't happen again. Trevor?
All right. Thanks, Claire. That was shocking. I'd like to thank Andrew for leaving me to the end. And it's great to see everybody in person. I agree. I want to echo my fellow panelists. It's really nice to see. I know too many people here, which means I've been working in this industry for too long. I've been at FSRA for almost a year now, and I've had the opportunity to see PBR in action. So what I thought I'd do, again, as the Deputy Chief Actuary, and yes, I have a badge, as the Deputy Chief Actuary, I have an opportunity to engage with plans and really have some conversations. So I want to give you an example of something we actually did within the last few months. Now, hold your hats. We had a single employer pension plan that was transferring into a large JSPP. I know. Who would have ever thought such a crazy thing would happen? And following the transfer, there was only surplus assets remaining in the single employer pension plan. So the question was, well, exactly, shockingly, the employer wanted to share the surplus. How are we going to get this surplus assets out? What are the best ways? Well, unfortunately, after a transfer, the plan isn't wound up. So if you look under the Pension Benefits Act, which I know we all do every night, you can see the only way to get surplus is really through winding up the plan or through a surplus application through an ongoing plan. Well, we could have required the administrator to do a formal wind-up, but that would have been engaging actuaries, and no one likes actuaries, to produce a report with a bunch of zeros in it, and that would have been a lot of work and unnecessary work. So we worked with them, we consulted with them, exactly the PBR approach we've been talking about. We had conversations with them as to what is the most appropriate, what's the quickest way, how can we do this so that everybody can get what they want, which in this case was the surplus money out, in the easiest case possible, while still working with the Pension Benefits Act and regs. So that's what we did. So we actually went through the ongoing surplus application. It worked out well. And then once all the money is out, they can apply for a simplified wind-up. So I think that really shows a great example of when a plan sponsor approached us, we came up with a collaborative approach on really how to make this work within the Act, as well as really trying to be outcomes focused. Because what was the outcome we wanted? Let's get the surplus, and they were able to. So good news all around. Andrew.
Thank you, everyone. I want to pose the questions to the panel. So you guys have been talking about how you apply PBR in your day-to-day work. You actually have shared with us some of the success stories. But can you also share with us some of the challenges that you faced during the last few years as we were implementing the PBR? Who wants to start?
I'll go first.
Okay.
First is the best. I think
You're going to get Trevor to speak.
Yeah, I'm going to speak
Okay.
after because actually we have two sides of the same coin, I think. And if I thought of Trevor's first, I would have taken it. I think in operations, I think the biggest challenge would be to make sure we ensure consistency when we're making PBR decisions that may not fully align with a plain reading of the PBA. Over the course of the last year, FSRA has solidified its thinking towards plan amendments after reviewing the PBA regulations as well as our objects. Our general expectation is that amendments should be filed before they're effective, but sometimes that won't happen. And FSRA will need to take a PBR approach to determine whether that retroactive adverse amendment can be registered or not. In our proposed guidance, we actually encourage plan administrators who file amendments late to actually make a submission to us using our values of transparency, reasonableness, and equity as to why the amendment should be registered as is. And I think in some cases you could show that there's no negative impact on plan beneficiaries and we would just go ahead and register it. In some cases, maybe not. Trevor?
Yeah, the thing we're also very concerned about in taking a PBR approach is precedent setting and having, consulting firms, actuaries say, well, you applied it in this scenario, that means it applies in every possible scenario that we can think of. And that's not what our approach is. We're trying to take, again, an approach where we look at the individual circumstances of the plan and the situation that they're in, and we're going to apply a PBR approach to that. And that does not necessarily expand to other plans who are in similar situations. So why we're having these conversations, why we're saying this, so that we're hoping to engage in more conversations, with other actuaries, with plan sponsors, so that we can make sure to know what applies and what doesn't, because we're really, concerned with scope creep.
Trevor just wants more lunches with people.
I like to eat.
I would say, Andrew, that when we launched, there was certainly some trepidation, right? Like, what's this conversation going to look like? And so I think the main, this is a journey, right? I don't think we've used that term today, at least I don't recall hearing it, but I think that's really critical, right? Like PBR, we set it from inception, and in some cases, like I said earlier, I was blessed with the fact that I was able to start from scratch in some of the work we do, so a little bit, easier to launch into versus others. We're transitioning. Risha talked about some of the guidance. So it's a journey, and a journey that requires trust building. And I think, and I know from my own experience, but again, would love to hear from others who've been involved, that level of trust had increased, fairly rapidly once we got into the discussions. And just, by the way, that supervisory approach I mentioned earlier that we published it on March 16th, Monday, March 16th of 2020. I think everybody in the room probably remembers what happened March 13th, the Friday before. Very fortuitous time to be publishing an approach such as that. And but on the flip side, it really challenged us and pushed us to work through this. So I guess the challenge is really the opposite of collaboration, is not collaborating and not having that trust. We're really trying to avoid this sense of setting people up for an I got you type of moment. I had very fortuitously a conversation with a lawyer from in the insurance side, so I know she's not in the room here because she told me she's going to another session, but it was exactly about this topic, about trying to understand like that trepidation as to in guiding her own clients as to whether or not they should speak to FSRA, and never mind doing it proactively, like just when we reach out. So that would be the biggest challenge. And I think that, moving forward to we talk about guidance. The guidance, I can't understate the importance of the guidance. There are other guidances out there that we've established, like the roles and responsibilities that we use quite a bit. And as time goes on and we gain experience, then those guidance will also be enhanced and improved, in my opinion.
I'm going to say two things in terms of challenges. The first is pacing. We're a bit unhealthy in that when we think about the large plans every single day, that doesn't mean they need to hear from us every single day. So as we're, I don't know if we're a puppy, but as we are growing and developing into a future state, I think we have to be efficient in terms of the resources that we have and also the resources that the plans have. But at the same time, we are a fully functioning, up and running supervisor. So if something happens in the sector, we're ready to handle that, and we'll devote the resources we need for that. The second thing I'd say in terms of the challenge is tone, and I think Paul's team does a pretty good job at this. We're not cops on the beat looking to issue tickets. Although as a regulator, there's ultimately an enforcement component. On the other hand, we're not necessarily friends either. We need to be objective and critical. So we need to find the right kind of tone to establish our authority as the regulator, but at the same time to create a kind of a collaborative, cooperative, kind of critical space for discussion on the key issues. And I think that's a bit of a challenge. Not that we're not doing a good job, I think we are doing that, but it's a fine line that we need to walk there.
Anything for you, Risha? No?
Okay, good. So I still recall the days, 2020 is when we first issued the guidance on the actively monitored pension plans. We have our fair dose of pushbacks, and look at 4 years now. Is all part of our DNA in terms of how we manage and how we supervise the single employer pension plans. So I'm very hopeful that we'll achieve the same thing for all the other plans across the sector. One more question for the panel. So you heard a little bit about PBR. You heard a little bit about what what it really means. But what does it mean when the sector is going to interact with us in the future? How is that experience going to look like? We're doing away with compliance checklists. There's no more checklists or less of those. So what would be the experience with FSRA going forward?
How about I go first, Andrew? So some of you know, I am the parent of a teenager right now. It's a very painful experience. So bear with me for a second. When my son was little, I'd sit him down, do your homework, right? This is the expectation. These are the 2 hours that I'm allotting to force you to do your reading and your math. We did this for years. Now that he's a teenager, I have a different way of approaching him. My expectation, I will tell him, and I'll tell you honestly, he doesn't listen, is that he does his homework, that he attends school. I don't force him to do it. I expect that he does do it because he understands that that is the outcome that we're hoping to achieve, that he will graduate high school, that he will pass all his classes. So when you're approaching FSRA, you've got, and I tend to see, to be quite frank, the more complex, difficult, ambiguous problems. So this is my suggestion and actually my request to you. When you're faced with one of those complex, difficult questions that you are interacting with us on, think about what are the outcomes that we've articulated that we are hoping to achieve. They're in our statutory objects. They are protect plan beneficiaries and support the good administration of pension plans. With that framework, look and think about the particular problem that you are faced with. And let me know, because me or one of the members of my team are going to be reviewing your submissions. Tell us why we should permit whatever it is that you are asking us to permit. Like, what is the basis? Not just because it's a good outcome, in your opinion, but that it's a generally good outcome for plan beneficiaries, that it supports the good administration of pension plans, that it supports, to the extent that we can, it supports innovation, flexibility, better protection for plan beneficiaries. I can't guarantee you that I'm necessarily going to agree, or we will, the royal we, will agree with your interpretation, but there are a variety of tools that we may use in the circumstances, as Trevor's identified with his surplus example, to support the outcome that you're hoping to achieve. We're trying not to shackle you. We're trying to empower you to find solutions that work. One of the things I hear a lot about the pension sector is that it's very unique, and it's true. We have small, single employer, defined contribution pension plans to large, public sector, multi-billion-dollar pension plans. So one size isn't going to fit all. So when you're dealing with one of those complex problems, tell me, why should we, as the regulator, be exercising our discretion, or Mark's discretion, to support the outcome that you're hoping to achieve? So think of it a little bit differently. I would encourage you to think of it as, what is your administrator's fiduciary duty? Are you satisfying that duty when you come to us with that problem? And tell us how you did, and again, what it is that you're hoping to achieve supports your plan and is consistent with our statutory objects and the PBA.
If I could add to that, I just say it's important that you come to us with solutions as well. We're not here, I think Claire said it earlier, We're not here to give you the answers. If there's a complex problem and you've got a potential solution for it and you want to, workshop or discuss it with us, hey, we're open to do that. But what we're not here to do is tell you the answer, especially in a complex situation that may not fit directly within the Act and regs. So again, it's a bit of a give and take. Andrew asked, what are we looking for? Well, again, we're looking for collaboration. We're looking to have a conversation. We may not always agree with you. There's been instances in the last 6 months that I've been working here, I've been working with different consulting firms where they've come to us and say, we want to do this. And we're like, yeah, I know you want to, but unfortunately, I don't think you can, right? Hey, and then we said, can you go back, think some more, and give us with another possible solution where they've come back to us? That may happen. But the key point I want to make is that we're not here to actually give solutions to you, but we're here to, work with you on it.
Am I going to go first? I would say patience. I think in the past, FSRA has been very much a case-by-case, kind of like looking at individual problems. And I think PBR kind of like necessitates a holistic approach to problem solving. And solutions take time to develop. So I think it's just really being patient with us as we kind of think through what PBR looks like in a very prescriptive piece of legislation.
I think we're kind of speaking to a theme here, because in terms of what supervision looks like, the buzzword that I had was highly analytical. I think I see our supervision as an historical kind of activity, and by that, what I mean is we really need to understand the facts, the policies, procedures, and the context of each plan. And only by having that understanding can we be in a position to have a principles-based response. So that means looking at documents, means looking at internal reports, talking to people, asking questions, and really digging into the issue. I think when it comes to developing a view, there will be some issues which are clear and obvious, and then there'll be other issues where that's not the case. And in those situations, it's important for us to be very clear and transparent about our premises and our reasons for coming to a particular view. So I think it's a highly analytical process. I mean, this feeds off the things we've talked about earlier around ambiguity. But I think that's the reality of principles-based regulation.
Thanks. And from my perspective, I just so I mentioned earlier on the single employer side how we implemented our new approach during a tumultuous time. So the analogy is flying the plane as you're building it, and we were also learning how to fly it and going through turbulence. That's now steady state. I don't even want to use that word, because actually we've got a team now built, and we're really focusing on our own, I call it internal governance, so how do we continually improve on our approach? So that's why I'm really anxious to get feedback and encourage that again. And on the multi-employer side, really exciting times, in my opinion. I feel really blessed to be having a front row seat to a time where we have this permanent framework being moved across the finish line. Right as we ourselves are wrapping up the several years of work we've been doing very collaboratively with the sector that are, as I said earlier, very integrated. So that's going to be an exciting time coming up over the next year. And then lastly, the examinations approach. I didn't get much into it. Happy to go into it more, and very much looking forward to getting feedback from those in the room or anybody who's part of our future state examination process to make sure we are truly being principles-based as we'd like to be.
Thank you, everyone. Hello? Yep. Thank you, everyone. So we've spoken for a good 50 minutes, and it's time to open the floor, the questions to the floor. So if you have any questions, sorry, what? Oh, good. Oh, okay. So, sorry, the question
Next
got
question.
cut off. So please submit your question through the app. So the first question is FSRA overextending its interpretation of the authority of the PBA, Pension Benefits Act?
I think that's probably
I
me,
think that's
right?
you.
No.
Next question.
No. So no, I would not be sitting here saying that so confidently if I didn't believe it to be true. It's not just a glib answer. I would say, and this is a little bit behind the scenes, we are quite rigorous in our interpretations. When there is a particularly controversial interpretation, we go outside to make sure that our interpretation isn't just supporting the outcome that we want or we desire, right? So it's careful, it's rigorous, but I would say this, and there's disagreement on this in some relatively recent guidance. You're not going to agree with us necessarily, but I would say our interpretation fits within the scope of the PBA. It fits consistently with our statutory objects, and it is supported by case law. You may not like the outcome that we're hoping to achieve or the interpretation that we take, but I wouldn't say that we're overextending. It probably is a surprise to many of you, some of the positions that we're taking. Some of you may not agree with them, but I would say they're rigorous and careful, and they're vetted. I mean, I would say, without going too much behind the scenes, that there's a very long process before we come up with guidance that starts with the identification of a regulatory problem that Claire spoke to in the plan amendment guidance. What are the outcomes that we hope to achieve? Consultations with a variety of stakeholders multiple times. So if there is an overextension of our authority, that truly was the case of an overextension, then I think it would come to light well before the guidance was actually published, and certainly before it is public. But that doesn't mean that everybody's going to agree with me. But I will say I will stand behind our interpretations.
Thank you, Risha. I think also is sometimes is the environment, the sector is evolving as well too. So we have no choice but to interpret it, and we have to apply a principle-based approach to interpreting the act, again, laying over it, our object. I turn to the target benefit plan funding framework. It's one where you don't have prescribed PFAT. And so what are we going to do? We're going to use a lot of judgment applying the principle base in terms of how we're going to be administrating the act and the regulations thereunder. So next question. I'm sorry, I have to read it, it's a long one. So there is a perspective that the large public sector pension plans are too big to fail. Can you tell us about what you see are benefits of supervisory framework that is planned for release in 24-25, and what are you hearing about it from the sector, how it's being received? I think this belongs to you, James.
This is an interesting question. I think, large public sector plans too big to fail. That's sort of bringing a banking kind of analogy or banking idea over into the pension context. But we know that the Bank of Canada in the pandemic established a liquidity facility for a number of the large plans. So to the extent that the pension needed that facility to avoid default, I guess you could say they're too big to fail. In terms about whether governments would permit reduction in benefits, that's an entirely separate discussion. The benefits of the supervisory framework, I think, partly it's just being transparent to the sector as to the principles by which we are, undertaking our supervisory activities. So there's transparency and predictability, and there's a basis to have discussion on those principles. And I see the questions disappeared. What's the second part of the question?
What do you see as the benefit of the supervisory guidance?
Yeah, I think the benefit is, again, just being transparent about how we do that. And the key thing about, our prudential supervision, I think the too big to fail brings in this concept of, are these plans systemic? Do we have to worry about systemic issues? And I think our view is that, as prudential regulators, if we keep the plans or if the plans are able to govern and manage their own risks, hopefully they don't get to a spot where there's any systemic implications. So that's how I'd sort of rationalize that.
So some of you know that I've been in the industry for a while. I'm coming up 38, 39 years, so I've been around. And my career spanned not just consulting, but also staying with a large plan. So too big to fail, not in the sense that it will be insolvent in that sense, but there will be hiccups, along the way. I joined a large plan. So I started signing a large plans in 2002, and I joined the plan in 2008. Bad time to, to be associated with a big, large plans. My fate, that is. But there will be hiccups along the way, right? And the road to recovery will generally be very long. And so what do you do in between? Well, you can either, as I think Mark mentioned this morning, you can either increase contributions or cut benefits. But when you look at some of the large plans, the contribution rates are 20% plus, employee-employer side combined. And so there's really not a lot of room to go. So again, we're not there to question, but we are there to kind of monitor and make sure that the right protocol is in place. We're not there to try to replace the board to be the fiduciary, but what we're doing will hopefully help spot a light there. So we still have some question time. So if restated plan texts are filed retroactive to the amendment date with no material impact on members, would it be agreeable with FSRA? Thanks. And this is in light of your comments to file amendments prospectively. So for those, I hope everyone's aware that we actually had a consultation just finished, second consultation just concluded on plan amendment guidance, specifically with retroactive amendments. There's been attracting a lot of comments. So I'll let Claire, you speak to it first? And then
Sure, I'll speak to it first. I mean, material impact on members, I'm not sure what that means. I mean, I think I'll take a bit of a back step. I mean, I think in the operations team, we see like six types of amendments being filed with us. Housekeeping, we don't care about those ones. Benefit improvements, all good. What else? Legislative required, legislative permissible. And we see collective bargaining amendments that are filed late with us, and they're collectively bargained, so we're not going to interfere with that practice. And it's really those retroactive adverse that we're going to have to think through. I mean, the one example I was going to say in my speaking remarks was FSRA views an increase to DC member contributions as being adverse. If filed late, let's say it's filed a year late, well, would we go back and require those contributions to be, given back to the members? That seems like an odd thing for us to do, of giving them back pension or retirement monies that was in a pension plan. So I think it really depends. Risha?
It's hard to answer the question, to be honest, because it's going to be very case specific. So how about this? I'd flip it. If you're filing a restated plan text and it is retroactive, why don't you make a submission as to why we should file it in light of the guidance, which outlines what are the things that we're going to think about. So I think the principles were transparency.
Transparency, reasonableness, and equity.
And equity. So did you notify members that there was a file plan text? Do they know? Were they notified of any of the changes, which are, in this case, non-material? What are the non-material changes that may impact members? Can you outline those for us? Are they equitable? So, if you answer, like if it's transparent, equitable, not really taking anything away, the chances are good, but make a submission. Call up and talk to your pension officer and Claire and chat about it, and we'll talk about it.
I think that's quite a learning in terms of drafting guidance that are principle-based, because as I mentioned before, previously, previous regime, we would have very prescribed details as to how you comply and not comply. We'll never be able to write a guidance that will be exhaustive enough to cover all situations. We try to clarify it through our guidance by giving examples, and yet some of the comments we receive is, well, your example is just not exhaustive enough. Well, does that equal prescription? I'm not I think all comments are welcome here, but I think people need to be aware that this will be part of the principle-based regulations. So I'll leave it at that. The other thing too is that, there are different views out there. Certainly some people who wrote to us feels that we actually have overextended our ability to, or authority to interpret the PBA, but there's also a whole different side where they're very supportive of what we're doing. So there's always two sides to it, but we haven't concluded that. We'll still continue the dialogue with the sector. Sorry, Risha, you have something to add? Okay. We still have time for a few more questions. Okay, what is the no, I'm not editing it, I'm just trying to, to read it. What is the future of single employer DB plans? Will PBR mean more work for single employer pension plans? Who wants to answer it? I can answer it, but you can too.
It might be teamwork here, but because I mean, they're two very different questions, right? What is the future of SEPPs, or single employer DB plans? That's a big, broad question, which I think a lot of people have an opinion on. I mean, they've clearly been on the decline. I don't think that's any big secret. They've been that's been the case for a long time, and then now we've got the Pension Protection Act on the table. So, I mean, we're all trying to figure out what the implication of that is. In terms of the PBR, though, the second part of the question, or really the second question, which is, will PBR mean more work for single employer pension plans? I think my short answer would be no. I'd love to know more about the context behind this question. It's an anonymous question, but please reach out to me directly if you want to give me some more as to what's behind that. Thinking maybe just about the examination process as one example, though, we definitely are very, very much aware, and as we are with our single employer approach and then the future state MEP approach, it is about burden, right? And then, you might think, or maybe the question's stemming from this data collection and engagements and the time involved, and yeah, certainly that could be considered work, but I would suggest that the outcomes of our work and the takeaways is much more value add to the fiduciaries, and understanding, what is going well and maybe where there's opportunities for improvement. And the examination process is going to very much move away from that, where we select plans much more on a dynamic basis. It's risk-based, and the one word we haven't used, or at least I don't recall hearing, is proportionality, right? Is the amount of effort that we're going to put into our engagements and then the examinations is going to be proportional to the level of risk. So ideally, the work will actually shrink if it's less risky.
So let me add my perspective. I'm a pension geek all through and through. I certainly would like the future of single employer DB plans to continue to flourish. Might not be the right word. At least stop the bleeding. I think it's again picking up from the Pension Awareness Day. I think retirement security is going to be more and more important going forward. With people living longer and longer, with an aging population, we will collectively find a way to make sure that there will be more pension coverage, whether it's through a single employer pension plan or through a multi-employer pension plan or a large plans. Will PBR mean more work to single employer pension plans? It might. It's kind of funny because I certainly was on the other side. I certainly had my fair share of complaints to the then regime. It's sort of like, okay, well, it's so prescribed. You're increasing burden. You're driving the last nail to the coffin. We'll now make it a little bit more flexible, and hopefully, as Paul said, it might mean more work, but value-added work to make it work and to make it flexible.
And I would say there's a possibility in a mature framework for PBR that it's actually less work. That's what I'd hope, right? Less burden. So let's talk about well-managed plans that beneficiaries are protected, and if you have a problem, you call up the regulator, and we try to develop a solution that doesn't require you to do unnecessary work. So there are examples of that come up. Trevor's example on the surplus, there could have been, we could have said you need to go through a formal surplus sharing regime. You need to submit a surplus sharing application or an opinion on historical entitlement. We didn't do that, right? We found a solution that worked. So the other thought I have is that we certainly are in a transition, right? We're all trying to figure out what are the shared outcomes that we should be achieving and how to do that. So it'll take time, and I think, Claire, I appreciate that. Let's be patient with each other. We're not trying to actually increase the burden. I think, as Andrew said, we're trying to increase flexibility, support innovation, while trying to achieve our statutory objects. So I think it could be good. It may not be good always, particularly in the more complex circumstances, or easier, but the idea is hopefully more effective supervision that focuses on the real problems that matter.
Thank you. Do we have time for one more question? We do, right? Okay, thank you. So this question is for you, Trevor. So as an actuary, dealing with numbers seems like it's always black and white. How do you balance the rigor of working with numbers with the flexibility of PBR in your work? People know that actuaries are not that black and white.
I always joke that I'm not good at numbers, that's why I became an actuary. First of all, thank you for naming me in the question as opposed to the other one, which anybody could have answered. But again, I think that's something we're dealing with as the regulator right now, is that, again, the answer isn't necessarily, like, again, liabilities are liabilities, but the way we get there may be different, and what we're actually going to do with them and how we approach them. What we're really looking at is, again, different circumstances and special situations that the Act and regs may not specifically apply to. Or if you as a plan sponsor, if you're working with a plan sponsor, there's a situation that's a little ambiguous within the Act, or you want more guidance, that's the PBR approach, especially within the actuarial team, that we're looking to have conversations about. Or if there's a difficulty, if there's something within the Act and regs that you can't, that goes, it's contrary to what you want to do, or the ultimate goal of the plan sponsor, how can we work with that? We're not looking to change the numbers. Numbers are what the numbers are. That's why it's great to be an actuary. But at the same time, we want to be collaborative and work with you on it.
It's great. So do we have any more questions, or should I? One more. Okay, last one, and before I close. If you have a concern about the risk management governance issues at a JSPP or large public sector pension plans, what will you do about it? James, what will you do about it?
Personally, James, what will you personally do about it?
I'll sit on it for a few weeks and then think about how to broach the subject with Andrew and then further up the food chain. Yeah, this is a good question. So it speaks to a few things. It goes to, sort of what we can do as a prudential regulator and also as a process. So, if we have a concern, I think we would first of all have to identify that there's a concern, and then there's a bit of a progression involved. That is, we'll have to think internally, okay, is this really a concern? And we have internal expertise. We have senior advisors that assist us. We have other people that, within our organization that are fairly experts. So there'd be an internal discussion about, is this a real issue? Second is then we have conversations with the plan management. Okay, are we understanding this right? How do you see the issue? And then ultimately, we would look to the management to see if there's a way to remedy that. Depending on the severity and the process, I think what we could see is then a situation where we would make our views known, assuming that we're correct that there is an issue. We would have a process where we could make our views known to the plan, likely through correspondence. That would be accessible by the board as well as management, and we'd look to the plan to either rectify that issue or give a satisfactory explanation as to why no action is taken. That kind of a process ultimately is one of transparency, and it allows the plan visibility into concerns, but also allows the fiduciaries of those plans, I'm thinking here specifically of the board and the executive management, they also have visibility, and they can, with that information, they can then decide what their fiduciary duty is and respond to that issue. So that's how I see what we will do about it. I think there's, ultimately we have to rely on the plans as plan administrators to exercise their fiduciary duty. And depending on the situation, we'll see where things go.
And in a way, that's not different from how we've been handling single-employer pension plans and multi-employer pension plans. We have a dialogue to understand where the gap is, where our perspective have a mutual understanding, and then take it from there in terms of coming up with a remedial solutions. So time is up. I want to conclude by giving you, I guess, summarizing what I believe to be principle-based regulations hearing from my fellow panelists. I'm a simple guy. I'd like to leave you with 3 thoughts, just 3 things. First, PBR is a cultural change. It's a change management on our part of the regulator, but it's a two-way street. It's also a change to the sector. We change. We're doing away with prescribed rules. We're doing away with prescription lists and all that stuff. But it's also a culture change on the part of the sector. We need a certain level of open-mindedness to be able to make PBR a success going forward. So that's point number 1. Point number 2 is good faith and trust. As I mentioned before, our going in position when we look at a pension plan, whether single employer, multi-employer, or LPSPP, is that the going assumption is that you know what you're doing. You know what fiduciary duty is. We're not there to catch you. We're not there to catch thieves. We are there to collect data to verify that you are doing what you're doing. Show us as opposed to just tell us what you do. It's a verifying exercise to exercise and discharge our duty. A third one is collaboration and cooperation is a key thing. You've heard the example through the single employer pension plan, the multi-employer pension plans, and I'm hoping to see that from the large plans as well too. PBR might feel that is 2 steps forward, 1 step backwards. That's growing pain. You need time to adjust. Well, where's the list, right? The first question that came, where's the list? Well, there's no list, okay? People might think that this is, I was once in a conference about a year ago, and I was on the panelists like this, and they said, well, this is a rise in regulatory activism. And I said, well, that's a good thing. That's a good thing because rise in regulatory activism means that we care. It doesn't mean that we get it right the first time. We care, we have the courage to try, and if it's wrong, we rely on the feedback loop to course correct immediately. So that's all the 3 points that I want to leave the sector with. Again, let me repeat, it's a culture change, two-way street. Faith and commitment, trust is critical, and collaboration and continued communication. So I want to thank everyone for participating. Great questions. I want to thank my colleagues in the panel to share their experience with us. We will be around. I hope to see some of you staying behind, for our refreshment bar, open bar, or something like that. So thank you very much, everyone.